petition and appeal in the matter of HM Attorney General and Zedra Fiduciary Services Limited.
Yes, Mr. Pearce.
May it please your lordships and your ladyship, in this appeal, I and my learned friend Mr Daniel Burton appear for the appellant, Zedra Fiduciary Services UK Limited, and my learned friend Mr William Henderson appears for His Majesty's Attorney General.
Yes, I can tell you that we have read the skeleton arguments and the judge's first, second and third judgments and the relevant sections of the Charities Act.
My lord, that's most helpful.
And can I also say that we don't think we will be particularly assisted by the latest updating report. The figures, precise figures, don't matter. We know what the order of magnitude is of both sides of the equation.
My lord, I understand that point entirely, and may I first deal with our application?
Yes.
We do seek permission to be able to refer to the three additional documents referred to in Mr R's witness statement, namely the letter from the Debt Management Office, an updating report from Professor Ellison, and the latest accounts of the charity, and actually fourthly a letter from Sir Stephen Bubb. As your lordship rightly in my respectful submission points out, these do not affect the merits or structure of the arguments in any way. They simply enable the court and the parties, if they so wish, to refer to the latest available financial information.
Mr Henderson, is there any objection?
My lord, in the correspondence we said we neither opposed nor objected for the reasons your lordship's already given. So that
All right,
remains
well, we'll let it in for what it's worth, Mr Pearce.
My lord, I'm obliged. My lord, the court already knows that Mr Justice Zacaroli held that the purposes of the National Fund have failed.
Yes.
And that the court has jurisdiction to apply the property comprised in the charity cy-près. And the criteria by which the court has to determine the correct cy-près application are set out in section 67(3) of the Charities Act 2011, which is conveniently set out in the second judgment, if I may call it J2, at paragraph 10. J2 is tab 9
Yes.
of the core bundle. And as the court knows, the learned judge held that factors A and B favoured the Attorney General's scheme, and he by implication held that factor C favoured the trustee's scheme, but not sufficiently to outweigh the effects of factors A and B. And our submissions in this appeal are that the learned judge was wrong in his approach to all three factors. He should have held that factor A, properly understood, favoured the trustee, that factor B is neutral, and that factor C supports the trustee's scheme more strongly than he recognised. We submit that factor C points conclusively in favour of the trustee's scheme, a fortiori when combined with the other two. And as the court knows, the Attorney General, by her responder's notice, submits that the learned judge erred in failing to hold that factor C supported her scheme. So, my lord, all three factors are in play in our submissions. My lord, what I propose to do with the court's permission is firstly to make my submissions on section 67(3) and then finally refer, I hope, briefly to the authorities. My lord, that, as I've indicated, the text of section 67(3) is conveniently set out in paragraph 10 of J2 at page 119 of the core bundle. And the three factors in that section are arranged in a logical order. One starts by looking at the spirit of the gift that has failed. So one's looking there just at the failed purpose.
Well, isn't the spirit broader than the purpose?
My lord, yes, but one is at this point only looking at the trusts that have failed. One isn't at that point
No, I
considering
follow,
any
but-
further
but-
purpose.
If I've understood correctly, spirit of the gift, whatever its derivation, and nobody seems to know where the phrase comes from, is broader than the purposes of the failed trust.
My lord, precisely. My only point was that at this stage, one is not looking at any proposed
No,
alternative.
we're looking
purpose.
backwards rather than forwards.
You're looking backwards, exactly. My lord, the second factor, factor B, requires one to compare a proposed new purpose or purposes with the failed purpose. So at this stage, the inquiry is broad enough to look at what is being proposed. And in this case, as the court knows, there were two alternative proposals. And the third factor, factor C, in our submission, is looking at the proposed new purpose or purposes in isolation. Do those proposed new purposes satisfy the need for the relevant charity to have purposes which are suitable and effective in the life, current social and economic circumstances? So there is a kind of logic to the structure. One starts with the past, as your lordship has said, and moves progressively to the future. My lord, in relation to factor A, the spirit of the gift, as the court knows, the learned judge held at paragraph 46 of J2 that the spirit in which the gift was given was to benefit the nation and all its citizens by attempting to free it from debt. Our submission is that that was too narrow a formulation, and that the spirit of the gift has two elements. First, a desire to benefit the nation without a restriction to repayment of the national debt. And second, a desire, by setting an example, to stimulate altruism in others. And as the court has seen, we do not pursue an appeal against the learned judge's rejection of a third element that we formulated at the scheme hearing. The meaning of the term spirit of the gift has been, if not defined, at least described by this court in Varsani and Dasani, and the relevant passages are conveniently quoted by the learned judge in paragraph 11 of J2.
Sorry, which paragraph?
Paragraph 11, my lord, on page 120 of the court bible.
Yes. What is the relationship between spirit of the gift on the one hand and general charitable intent on the other? Because in his first judgment, when he was looking at general charitable intent, judge seems to have held that the intent was broader than simply discharging or reducing the national debt. So how do those two elements relate?
Well, my lord, we touch on this very diffidently in our skeleton.
Yes.
My lord, the first point to make, and I emphasise, is that the two concepts are entirely different.
Right.
The question of whether a gift has a general charitable intent, such as to prevent it from failing ab initio, is an entirely different exercise to determining the spirit of the gift for the statutory purpose of making a cy-près scheme. So it would be a heresy in our submission to conflate the two concepts. But as your lordship has noted, the learned judge in his discussion of the entirely separate concept of whether a general charitable intention is present, did analyse the terms of the gift in a way which strongly supports our submissions about the spirit of the gift. And I'll be taking the court to those passages. There is in our submission, recognising that the two concepts are quite different, a clear tension between the way in which he interpreted the gift to discover whether it had a general charitable intention and the way in which he interpreted it to discover the spirit of the gift. His approach in the latter context was far more restrictive than it was in the former, and we say that applying a consistent approach, he should have found the spirit of the gift to be much broader than he did. So, my Lord, the concept of the spirit of the gift is obviously an inherently ethereal one. How does one take the argument forward from a mere assertion as to what the spirit of the gift is? In my submission, there are 2 points that one can derive from the statute that help with this. The first is that ex hypothesi, the original gift has failed. So what one is doing in applying the criteria in section 673 is discovering something in that failed gift which is capable of suggesting a new purpose. So the purpose has died, but the spirit lives on. And in order for the spirit to be of assistance in finding a new purpose, it should, in our submission, be one should adopt a generous approach when looking for it. If you confine it narrowly to the old purpose and don't look broadly, you are not going to get the assistance that the section intends you should in formulating a new purpose. And the second point one can get from the section is that paragraph A is followed by paragraph B. Paragraph B preserves the need for the new purpose to be close to the original purpose. So paragraph A must be intended to do something different. Paragraph B anchors, to the extent that it's desirable to do so, the new purpose to that which has failed. Paragraph A, we say, if you put the two together, it's intended to broaden the inquiry. Now, as I've indicated, we submit that the spirit of the gift has 2 limbs, and the only substantive difference between our formulation of our first limb and the learned judge's formulation is that he confined it by reference to freeing the nation from debt, whereas we say it should be unrestricted. And our reasons for saying that the learned judge was wrong to restrict it in that way are set out in our skeleton, which I would like to use as an agenda in paragraph 35.
Yes.
My Lord, points 1, 2 and 3 in paragraph 35 are submissions based on the documents to which the learned judge referred. And in our grounds of appeal and in our skeleton, we confine our submissions to those documents. We do not seek to take the court to any additional documents from the contemporaneous material. And in our submission, by reference to a submission which I think is going to be made on behalf of the attorney, to confine one's appeal to the documents on which the judge relied is not island hopping. If I can continue the metaphor, it is following an itinerary that has been mapped out by the judge. So just taking those 10, and the learned judge referred to the trust deed and to 10 additional documents. And with the court's permission, I will go through each of those documents as briefly as I can. If we can turn to the supplemental bundle, the trust deed itself is at tab 1. And the short point to be made about that is that on page 1, the charity is described as the National Fund. Turning to the contemporaneous documents on which the judge relied, the first is at tab 28 of this bundle. This is a memorandum by Sir Otto Niemeyer, who at that stage was a Treasury official, to the Chancellor of the Exchequer, Winston Churchill, in which he says this: "I've been approached by a gentleman who has forbidden me to mention his name to anyone, with an offer to contribute £500,000 immediately and possibly more later for the redemption of the national debt, provided the money may be used in the hands of private trustees to accumulate under a trust agreement. The difficulty about this is that under the law as it stands, a trust cannot run beyond a certain period of years. My friend's idea is that if such a trust existed and its accounts were published every year, so that people saw a fund heaping up in this way for the redemption of the debt, other rich men would be induced to follow his example. He holds the view that the ocular demonstration of a growing fund would attract far more support than the mere announcement of contributions which have been applied immediately to the cancellation of the debt." And then he goes on to explain that legislation will be necessary, and the court sees that on the second page of this document, Winston Churchill annotates it to say, "I see no objection to a small bill for so attractive an object." So, my lord, in that document, the idea of encouraging others is strongly present, but the proposal is simply explained as being a fund to accumulate, eventually to redeem the national debt. But of the second document to which the learned judge referred is at tab 35. And the court has a dramatis personae, but I should mention that Sir Otto Niemeyer had by this stage moved from the Treasury to the Bank of England. So he's written to at the Bank of England in this letter. This is a letter from Lord Revelstoke, who was a director of bearings, to Sir Otto. And he says this: "A correspondent has handed to Messrs Baring Brothers and Co Limited a fund of cash and securities, which at today's prices amounts to £500,000, to be held in trust for the nation, provided certain proposed legislation passes into law during the present session." So, my lord, at this point, the trust is a trust for the nation, and that, of course, is entirely consistent with our submission. The third document on which the judge relied is at tab 36. This is a letter from Sir Otto to Winston Churchill, the Chancellor, of the following day. I forward to you a copy of a letter which I have today received from Mrs. Baring's on behalf of a correspondent of theirs who wishes to give £500,000 to be held on trust for the nation in certain circumstances. And he goes on to explain why the letter is being written. The fourth document is at tab 44. This is a letter from the Chancellor to Lord Revelstoke, Lord Revelstoke, I'm much obliged to you for sending me through Sir Otto Niemeyer the terms of the very generous offer made by a correspondent of Messrs. Baring's to place a fund of £500,000 in trust for the nation to be applied in reduction of the national debt. So at that point, you have the two concepts combined, and our eventual submission is that that is an accurate description of the concept. The letter goes on. I shall be obliged if you will kindly convey to the anonymous donor the warm thanks of His Majesty's government for this magnificent gift, which they are most glad to accept on behalf of the nation on the terms proposed. The government hope and fully expect that such an outstanding example of public spirit may prove an inspiration to others and may mark a turning point in the history of the debt. So there again, one has the concept of an example to others being referred to. My lord, that was the fourth document. The fifth document is at tab 52. This is a letter from Winston Churchill to Lord Revelstoke, with reference to my letter of the 18th of November last. The clause in the superannuation and other trust funds validation bill framed to cover the erection of a fund to be applied to the reduction of the national debt was duly passed into law just before Christmas, and I enclose a copy herewith. I understand that the text of the clause as framed met with the approval of your correspondence advisors. Then the letter goes on to discuss income tax, and it tactfully invites the donor to complete the trust. The final paragraph reads, when the gift has been completed, I should like to take an early opportunity of expressing publicly my high appreciation of the munificence of your correspondence action, and of referring also to the great public benefit which might follow from the copying of this generous example. So once again, one has there the example that is being set. The next document is at tab 53. This is Lord Revelstoke's reply to Winston Churchill. I have the honour to thank you for your letter of the 5th instant, with which you are so good as to enclose a copy of the clause in the superannuation and other trust funds validation bill, framed to cover the creation of a fund to be applied in the reduction of the national debt. I note that this clause duly passed into law, and then he deals with the other matters that Winston Churchill had raised. And over the page, we shall leave it to you to adopt such course as you may think fit in accordance in connection with the publication of this letter, and if, as you intimate, the occasion seems to warrant a public expression of your thanks, I have reason to believe that such action will be appreciated by our correspondent, who, while determined to avoid personal publicity, evidently sets great store on the possible influence of his example on others. Again, the function of the gift as an example to others is stressed by by the donor's representative, Lord Revelstoke. My Lord, the 7th document is at tab 54, and this is the most important, because it is the only document which contains the donor's own words. And in this document, Lord Revelstoke writes to the Chancellor, we have the honour to inform you that we've received from a correspondent, whose name we are not authorised to disclose, but from whose letter we are allowed to quote the cash and securities to which reference is made below. Our correspondent writes, gifts to the nation of historic sites, buildings and works of art are happily frequent. Gifts to repay debt comparatively rare, this last being a dull objective but bringing with its own accomplishment certain comforts of its own. To repay the national debt may be thought to be beyond the needs of individual, beyond the reach of individual effort, but as a beginning towards this end, I'm placing at your disposal, as trustees for the nation, some £500,000 as the nucleus of a fund to accumulate in your hands and to be applied eventually to this object. I'm entrusting this fund to your house in order to secure the benefit of your long experience in finance and in the hope that others may from time to time be prompted to add to it, or on similar lines to set up funds of their own, citizens and city uniting in an attempt to free their country from debt. We should be glad to know that our acceptance of the trust meets with the approval of His Majesty's government. My Lord, in this letter, Mr Farrer is, in our submission, treating his gift as a species of gifts to the nation. In our submission, after the first semicolon in the second line of this page, one has to imply to the nation. It's purely a matter of style that causes those words to be omitted. So the sense of the letter is gifts to the nation of historic sites, buildings and works of art are happily frequent. Gifts to the nation to repay debt comparatively rare. He's not talking about any other kind of debt. He's talking about the nation's debt. So that is how the donor saw what he was doing. And it would be convenient at this point to look at the way in which the judge dealt with our submission on the meaning of this letter. He discussed it at paragraph 44 of J2. So to find that, we have to return to the core bundle, and J2 is at tab 9. The paragraph 44, the learned judge says this. This is in support of his limited formulation of the spirit of the gift. It is also supported by the fact that in the key correspondence emanating from Mr Farrer or others on his behalf, reference to a gift to the nation were invariably qualified by reference to the repayment or redemption of the national debt, either expressly or by implication. This is most clearly seen in Mr Farrer's own letter. Mr Pearce submitted that Mr Farrer in this letter equated his gift with other gifts to the nation, such as gifts of historic sites, buildings or work of art, and that this supports his conclusion, or the conclusion, that the spirit of the gift was to benefit the nation without qualification. I disagree with that reading of the letter. On the contrary, Mr Farrer was contrasting his gift to repay debt from those other types of gift to the nation. I think that the final sentence of the letter is a better clue to the spirit of the gift, where the hope was expressed that others may from time to time be prompted to add to it, or on similar lines set up funds of their own, citizens and city uniting in an attempt to free their country from debt. Well, my lord, the learned judge is there by the use of the word other types of gift to the nation, appearing to accept that this is a gift to the nation. So
Well, your reading is that the contrast that Mr. Farrer was making was between eye-catching gifts to the nation and dull gifts to the nation.
My lord, precisely. And my lord, that in our submission is the correct reading of the letter. They're both kinds of gifts to the nation. And my lord, one gets that too from J1, where, as your lordship has already pointed out, the learned judge considered the terms of the gift in a different context.
Yeah.
J1 is in the supplementary bundle.
Yeah, and it's paragraphs 116 to 119.
My lord, yes, if we can look at those. My lord, dealing with this point generally, from paragraph 108 onwards, the learned judge gives what we would respectfully submit is an impressive analysis of the concept of general charitable intention. And he reaches his conclusion as to what that concept is in paragraph 115. In paragraph 116, he says, there's a logical distinction between this question and this is a yet further question we have to deal with, whether the gift effected by the deed is subject to a condition precedent. The lack of condition precedent would not necessarily demonstrate the presence of a general charitable intent. On the facts of this case, however, much of the reasoning which led to my conclusion that the deed effected an unconditional and immediate gift to charity also supports the conclusion that there was here a general charitable intent. I refer in particular to the first, second, and fourth points relating to the terms of the deed and the indications to be gleaned from the extrinsic evidence. My lord, I don't intend to take your lordship to those paragraphs of J1. In addition, 1, GF himself, in words which were made public in Baring's letter of the 26th of January 1928, described the gift as being placed in Baring's hands as trustees for the nation and positioned the gift within the same bracket as more frequent gifts to the nation, such as historic sites, buildings, and works of art, albeit one having a dull objective. And 2, the fact, as demonstrated in numerous pieces of correspondence, that part of GF's desire was to encourage others to make similar gifts to the nation, supports the view that he had a broader intention of benefiting the nation beyond the specific purpose of discharging, or in some circumstances, reducing the national debt as identified in the deed.
Now, you've said, in answer to a question from me, that general charitable intention is not the same as spirit of the gift, and it would be heretical, I think was your word, to conflate the two. Do you say that the judge's subparagraphs 1 and 2, paragraph 116, are or are not relevant to the question, what is the spirit of the gift?
My lord, they're relevant to it. They're highly relevant to it because in both contexts, the learned judge had to ascertain Mr. Farrer's intention from what he wrote. And his intention is, if you like, a question of fact. It doesn't change depending on the context in which you are trying to apply it. The point I was stressing when I used the word heretical was that I didn't want to be misunderstood as suggesting that the legal consequences of something having a general charitable intention are the same as or coextensive with the spirit of the gift or something on those lines. But my lord, I do submit that in these paragraphs, the learned judge correctly identified what one can discover from the crucial letter about Mr. Farrer's intention, and that this supports our submission that the spirit of his gift was to benefit the nation without a restriction to the national debt.
And he repeats that at 121.
My lord, he does. My lord, if we may continue with the documents to which the judge referred, The 8th document is at tab 56 of the supplemental bundle.
I'm sorry, is it?
Tab 56.
Thank you.
My Lord, this is a letter from the Chancellor Winston Churchill to Barings. Gentlemen, accepting on behalf of His Majesty's Government the trust for the benefit of the nation inaugurated by your anonymous correspondent and alluded to in Lord Revelstoke's letter of the 16th of January, the 26th of January, I desire to express again the Government's warm thanks, which I have already in more informal manner asked Lord Revelstoke to convey to the donor for this magnificent gift. Among the motives which actuated the donor, as your letter shows, was the hope that others may be prompted from time to time to follow the example he has set on so spacious a scale. Hope to find occasion within the next few days of making a public announcement of his munificence. So again, a trust for the benefit of the nation is the concept.
But does that really matter? I mean, what Sir Winston Churchill thought about that is peripheral. What one is looking at is the intention of Mr. Farrer. And so the fact that Sir Winston repeats the mantra doesn't get you much further forwards, does it?
Well, my lady, obviously, Winston Churchill, what he says is, if you like, secondary evidence of,
or even colder than that, because he's repeating what he's been told by Lord Revelstoke, who's repeating what he's been told by the donor. And should we not be taking care? I know we're not unpicking everything that the judge decided, but should we not take care to make sure that we are not putting too much store by the repetition of a mantra by people who are further down the chain?
Well, my lady, I take your ladyship's point entirely. It's right. It's right to look at the way in which Winston Churchill described it, because he was extremely close to the creation of the gift, and also because this is one of the documents on which the judge himself placed reliance.
Absolutely, and I'm not trying in any way to unpick the judge, but I wondered whether, in fact, what you might be saying was that this is important rather than for what is specifically said, but also because everything is of a piece, but also it's the I hesitate to use the word spirit, but the spirit in which the gift was understood, let's put it that way, at the time, and in effect facilitated by the Treasury.
My lady, I would respectfully agree with that. This letter and others do show this, may I say, the sense in which the gift was understood. And although it's not a document emanating from Mr. Farrer, because it is part of a chain of correspondence between the recipient of the gift and the donor, it is, in our submission, relevant to ascertaining the spirit of the gift. It is sufficiently contemporaneous to be within the matrix of fact that Justice Chadwick referred to in Varsani and Jasani as being material from which one identifies the spirit of the gift. The ninth document is at tab 57, and that is a letter which has been transcribed at tab 58, and one sees that it's a letter from Hopkins, who was an official at the Treasury, to Mr.
It
Grigg.
was Inland Revenue, not that it matters.
My lord, I'm grateful that I was
We've
thrown
got-
by
the first letter that we've got is from Sir Otto to Mr. to
Yes, my lord, that is quite that I was thrown by the address being Treasury Chambers. Obviously, that in this context is in revenue, and it's simply a reminder that the donor would like to have the gift publicised. And the final document to which the judge referred is Winston Churchill's public statement, which is at tab 59. The Chancellor of the Exchequer desires to make the following announcement. The nation has just received a benefaction of a character hitherto exceptional in the relations between the state and its citizens. In the last few days, an anonymous donor has set aside the sum of £500,000 to be managed in trust for the nation. The capital is to accumulate at compound interest over a long period of years, ultimately, with all the accrued proceeds swelling progressively with the passage of time. It is to be applied in the reduction of the national debt. In order to facilitate this gift, Parliament was invited last session to make an exception to the law forbidding perpetuities and to declare long accumulations lawful when they had this especial object in view. The Chancellor of the Exchequer desires to acknowledge publicly the gratitude of His Majesty's government for this important gift, unprecedented in its character. He regrets that he cannot thank the donor by name. It is the donor's hope that others may from time to time be prompted to add to the fund which he has inaugurated, or on similar lines set up funds of their own. The Chancellor of the Exchequer states that action of this kind is inspired by clear-sighted patriotism and makes a practical contribution towards the ultimate, though yet distant, extinction of the public debt. My lords and my lady, those are the documents on which the learned judge relied. And if I may return to our skeleton argument in the core bundle. Which is at tab
35, weren't we?
My lord, yes. We are at paragraph 35. The submissions that we make based on that documentation are set out in paragraphs 1 to 3 of that paragraph. My lord, the point taken against us, if I can paraphrase it, is that the material, I'm not trying to put it as well as it will be put, but the material refers extensively to the repayment or redemption of the national debt. Well, that is obviously correct, because that was Mr. Farrow's purpose. The fact that much of the discussion in the contemporaneous documents is focused on the machinery by which his purpose will be achieved is not an impediment to the spirit of the gift being broader. And so, as we say at paragraph 4, the discussions in the correspondence of machinery, legislation, tax and the like, are consistent with the spirit of the gift being a desire to benefit the nation without qualification. My lord, our fifth point is that what the judge has effectively done in his formulation, the spirit of the gift, is to paraphrase the terms of the gift, and that is a clue to it being an insufficiently wide formulation of the spirit of the gift. So if one looks at the way he formulated it, which, if we stay in our skeleton argument, is is set out at paragraph 33, to benefit the nation and all its citizens by attempting to free it from debt. In our submission, there is no distinction for the purposes of the exercise of identifying the spirit of the gift between the nation and its citizens. There are different ways of expressing the same idea. Attempting to free it, that means the nation, from debt, can only be a reference to the national debt. There were no other. All the nation's debt is comprised in the national debt. So, if you take those 2 points into account, what he is really saying is that the spirit of the gift is to benefit the nation by attempting to free, which is much the same thing as reducing the national debt. So he's really formulating the spirit of the gift in terms which in our submission are a rough paraphrase of the purpose of the trust, and he's not, as Sir Andrew Morritt and Lord Justice Chadwick require in Varsani and Vasani, looking beyond that.
I imagine you wouldn't dispute that there are cases where the spirit of the gift can't really be separated from the purpose. And your point really is this case is one where a broader purpose is clearly discernible on the contemporary evidence.
My Lord, yes. My Lord, there are relatively few cases where the court has actually had to identify the spirit of the gift, and I shall take your Lordship's and your Ladyship very briefly to the authorities later on. But two of the cases, Varsani and Vasani being one and White Williams being the other, were cases where there was a schism between or within adherents of a religion for whose benefit a charity was established. And in both cases, the court essentially treats the spirit of the gift as being to provide facilities for worship for the community before the schism. Now, in that concept, that makes, if I may say so with respect to the court's concern, that makes excellent sense. You don't need to go wider than that to resolve the questions that arise as to what to do with the assets of the charity, given that the schism has arisen. This is a different situation where there is a very particular purpose which has completely failed. That's a rather different situation to where you have a religious community which is broken into two. Each half of the community is perfectly capable and wants to carry on its religious observances using the assets of the charity. This is a different situation, as the Lordship has perhaps indicated. My Lord, our final point in paragraph 35 is that Mr. Farrer cannot have seen reducing the national debt as an end in itself. He must have been looking further to the benefits that would flow from achieving that. And those are benefits to the nation in the sense that the nation will in that distant time be more prosperous. It will not have to fund the repayment of debt. And so that is not purely a financial matter. It is a matter which benefits the nation as a community and as a nation in a broader sense than in a purely mathematical, arithmetical one.
Is there a kind of sense in the background that debt is just in itself something to be avoided if at all possible? I mean, certain politicians sometimes adopt, or I'm thinking of Margaret Thatcher perhaps.
Yeah, my Lord, yes, it is plain, and I invite your Lordship to look at it, from Professor Elliott's report that in the time when this trust was set up, eliminating the national debt was a keenly held ambition. Perhaps I could just take your lordship and your lordship briefly to Professor Ellison's report where he discusses this.
Just before you do, could you help me about this? What is the status of Professor Ellison's report? There are two joint statements by the experts, but was Professor Ellison's report accepted as being accurate for what it said? I simply don't know.
My lord, it was. The learned judge relied extensively on it, as your lordship has seen.
Yes.
And the attorney had an equally distinguished expert. And as your lordship has seen, there were joint statements prepared by the two of them,
Yes.
at least in the early stages.
But I think Professor Porter's report was rather narrower in its scope than Professor Ellison's.
My lord, that is correct. But after Professor Ellison had produced his much more extensive report, they prepared joint statements
Yes.
in which they almost entirely agreed on the contents of the wider report that Professor Ellison had provided.
My lord, I wonder if I could just help on that. Insofar as the so-called expert reports may not be truly expert evidence, we accept the evidence of fact which is given about the nature of the underlying approach of government in the 1920s to the national debt and things of that nature.
Right.
So my submission is not necessary actually in relation to Professor Ellison to sort of pick into whether it's truly expert evidence or evidence of fact, one way or another. It's there and we don't dispute the factual evidence.
That's very helpful. Thank you, Mr. Henderson.
I'm most grateful, my friend, for that. My lord, Professor Ellison's report is at tab 14 of the supplemental bundle. And in answer to, or by reference to my lord, my lord's point, section 12 of the report on page 134 of the bundle
Yes.
deals with attitudes to the national debt in 1928. And strikingly, there was a sinking fund generated by something called the McKenna Rule, which is referred to in paragraph 12.4. And in paragraph 12.5, Professor Ellison refers to a report of the Committee on National Debt and Taxation established under Lord Colwyn, which supported the policy of paying back the national debt, proposing an immediate increase to the contributions to the sinking fund, so, my lord, that was the atmosphere of the time.
It almost went without saying that in the climate of the time, reduction of debt, national or otherwise, was indisputably a good idea.
Yes, precisely, my lord. One sees from Professor Ellison's report that the national debt increased hugely as a result of the First World War. And obviously, that was something that was keenly felt at the time. And there was a strong desire, that appears to have been a broad consensus as far as one could see from Professor Ellison's report, that it needed to be brought down. And your lordship sort of noted, you will have noted in the contemporaneous material that we've been through, that the aspiration of eliminating the national debt is felt. It is recognised as being distant, but Mr Churchill's references to that as an objective suggest that it was a genuinely held ambition at the time.
Well, the experts agreed that it was,
Yes.
and the experts agreed that the National Fund on its own would have been seen as being capable of
Yes.
paying off the national debt one day.
My lord, may we now turn to the learned judge's reasons for
Yes.
adopting a narrow formulation of this part of the spirit of the gift. For that, we need to go to J2 in the core bundle. Starting at paragraph 40, my lord, my lady, he gives 5 reasons in paragraphs 41 to 45, and those are introduced by paragraph 40, where he says that I agree that formulating the spirit of the gift by reference to its purpose is confusing. The purpose is the starting point, but necessarily the spirit must be broader than the purpose. I do not accept, however, that the idea that the spirit of the gift encompassed the reduction of the national debt can be dismissed so easily for the following reasons. And my lord, there is a question as to what exactly the learned judge meant by the word encompassed. In the context, we submit that what he meant was confined to, because that appears to be what is suggested by the idea that there is an idea to be dismissed. The idea that he's not agreeing to dismiss is the idea that the national debt is that the spirit of the gift is confined to reducing the national debt. So
you will accept, I take it, that the spirit of the gift encompassed, in the sense of included, reduction
Absolutely,
or
my lord.
elimination of the national debt, but you say it went broader.
my lord, precisely, and my lord, one of our we presented draft grounds of appeal to the learned judge. One of the original grounds was that the propositions that follow do not show that the spirit of the gift was confined to the national debt, was confined to reducing the national debt, and my recollection, it may be not shared by my learned friend, I may be wrong, is that the learned judge said in the course of argument that confined to was what he meant. I think my learned friend may not agree with that, but in which case obviously the court can't take it further. But just reading the paragraph as a matter of ordinary language, the context suggests that what he meant by the word encompassed was confined to. If encompass means includes but is not confined to, then obviously we accept that reduction of the national debt is within the spirit of the gift. Our argument, as your lordship has said, is that it's not confined to it.
But interestingly, in 41, he uses encompasses in a way which is different. If you're right about the first one, I'm not playing semantics, but
Yes.
that is encompasses in the sense of also includes.
Yes, yes. Well, yes. My lords, my lady, going through these 5 reasons, the first reason we say does not demonstrate that the spirit of the gift is confined to reducing the national debt.
Well, what relevance has an Act of Parliament got to Mr Farrer's intention?
Well, my lord, it could be said that it's part of the background against which his gift was made, as indeed it was.
But Parliament may well have wanted to encourage other people to set up their own funds.
Yes,
To reduce rather than discharge the national debt.
yes, my lord, precisely. My lord, I respectfully agree. My lord, paragraph 42 needs to be looked at with some care. My lord, he starts by saying, a gift to the nation, for example, a gift of funds to the exchequer to be used for government purposes, is not charitable, since, as was common ground, although government spending is for public purposes, it includes both charitable and non-charitable purposes. That's his first proposition. And my lord, my lady, we accept that is correct. He goes on to say, it is perhaps something of an anomaly, but it has long been held that a gift to benefit the nation by reducing the national debt, whether wholly or in part, is a charitable purpose, notwithstanding that the way in which citizens of the nation benefit from that gift is either by a reduction in their taxes or an increase in funds available for general public spending. See the first judgment 11. We accept that that proposition is correct. But he then goes on to commit what we say is an error, where he says the fact that in order to be a valid charitable gift, a gift to the nation had to be used in reduction of the national debt, supports the view that the spirit within which the gift was given was the relief of the debt burden on the nation. And my lord, it is, we submit, not correct to say that in order to be a valid charitable gift, a gift to the nation had to be used in reduction of the national debt. And the reason why that is wrong appears from the case of Rees-Smith, and perhaps it would be convenient to go to that case now. It's in the authorities bundle at tab 15. The facts of the case were that a testator by his will gave his rigid estate unto my country England for blank own use and benefit absolutely. It was held that that was a valid gift for charitable purposes, and that the residuary estate must be transferred to such persons as His Majesty should direct under his signed manual. And the reasoning of the court appears firstly in the judgment of the Master of the Rolls at page 228 of the bundle.
228.
9 of the report.
Yes.
First break in the page. The result is that I come to the conclusion that there is a definitive purpose, namely that the bequest is to be for England. That is good in the same sense that, although general, when the sum bequeathed comes to be used, it is to be applied to charitable purposes, as in Attorney General Webster. There is no area or purpose of distribution suggested which is not charitable. Why not then give effect to the plain meaning that it is for the advantage, within the meaning of the rule as the interpretation of the word charitable, of the inhabitants of England? In my opinion, therefore, the Attorney General succeeds upon his appeal. Under these circumstances, the right course is to hand the money over to the person designated under the signed manual by the supreme head of the country for the advantage of the country England. That supreme head, as Lord Eldon said, being the parens patriae, will cause it to be distributed in accordance with the law applicable to charitable monies. And he declines to be driven to an opposite conclusion by the case of Tapley.
Just dispel my ignorance, if you would. What actually happens to this money? Does somebody pick a charity under the signed manual? What in practice, once the direction has been given that the money should be transferred by the signed manual? I mean, does somebody say, right, we'll give it all to the National Trust, or we'll set up a new charity, or what actually happens?
My lord, I'm, as between the two of us, not the best place to answer that question.
Well, perhaps Mr Henderson will answer my question in due course, but I'm quite curious to know, because the judges simply say, oh, well, transfer it under the signed manual with no real indication about what happens after that.
Yes. Well, my lord, that is obviously, with respect, correct, but
Well, I asked the question partly because it has a bearing on your scheme, where you are giving the trustees discretion to decide what to do with the money.
Yes.
So it's of some interest to know what happens in these cases where you've got a bequest to the nation and it's transferred to somebody, we don't know who, under the signed manual.
Yes, well, my lord, one suspects, although it's not for me to say, but the answer is in many cases that it is applied in reduction of the national debt by being transferred to the,
That could be, yes.
by being transferred to the donations and bequests account maintained by the National Debt Commissioners. My lord, one gets some assistance on that point if one goes to the letter from the Debt Management Office, which your lordship has allowed us to refer to.
Yeah.
In the, if your lordships have it in the appellant's bundle,
So 555,000 given to the nation.
yes, if we could look, my lord, the origin of this letter, as you must appreciate it, is that we belatedly realised that the donations and bequests account maintained by the Debt Management Office is or may not be used solely to receive sums given in terms to reduce the national debt. And so we asked for a breakdown as between sums made specifically to reduce the national debt and those given on other terms, such as to the nation. And at the bottom of page 8 of the appellant's bundle, if that is the way yours is paginated, the court sees that the sums paid to that account include donations given on other terms, such as to the nation. And in fact, that those are, over the period of review, more significant than those given specifically to reduce the national debt. So that perhaps suggests that money given to my country, England, or
Will in practice be used to pay down the national debt?
yes,
And is that the implication, I'm sorry to be foolish, but is that the implication of the letter of the 11th of August that we have in the bundle, i.e. you've asked for that split, but all that money is being held by the Debt Management Office, so one assumes that it's all going down the same funnel.
yes, my lord, my lady, the donations, the accounts of the Debt Management Office are in evidence.
Yeah.
And they show that money paid to the donations and bequests account is used to reduce the national debt by redeeming gilts.
Can I just clarify one point? I may be missing something very obvious. At the beginning of the judge's paragraph 42, he says, a gift to the nation is not charitable. But I thought that's precisely what Rees-Smith doesn't say. It says it is charitable.
Maybe that he's distinguishing between a gift to the nation and a gift to be used for government purposes. That may be the distinction.
Well, but I mean, the gift in Rees-Smith was a gift to my country, England. I mean,
Yes.
How is that different from a gift to the nation? Beats me. I mean,
I think, my lord, that his first sentence has to be read with reference to the as a whole. A gift to the nation, for example, a gift of funds to the exchequer to be used for government purposes. So he's postulating a gift in
that as
those
an
terms.
example, though, doesn't he, of a gift? All right, and it maybe answers you if you're unwise enough to specify a particular purpose which might extend to something non-charitable, the whole gift fails. But if you just say in words simplest possible form, a gift to my country, England, or a gift to the nation, that's okay.
My lord, there was a discussion of this in the learned judge's third judgment, which is at tab 10 of the core bundle. Starting at paragraph 18, on page 136 of the bundle, the perceived error of law in paragraph 42 is as follows. In the first sentence I said, a gift to the nation, for example, of funds, a gift of funds to the exchequer to be used for government purposes is not charitable, since, as was common ground, although government spending is for public purposes, it includes both charitable and uncharitable purposes. Mr. Pearce rightly pointed out that a gift to the nation is charitable. To that extent, I accept that the opening words of the paragraph are too broad. However, as Mr. Henderson pointed out, that is because such a gift will be construed as limited to be used for charitable purposes. The remainder of the first sentence is correct. Indeed, as I pointed out, it was common ground. So, my lord,
So I think there the judge was accepting that a gift to the nation simpliciter is regarded as charitable because its scope is implicitly restricted to purposes which are charitable.
my lord, yes.
Makes one wonder why that is done in that situation. Why doesn't one adopt a similar approach to all those famous cases about gifts to charitable or benevolent purposes and all the other cases which have caused so much grief?
Indeed. In my submission, the court doesn't have to
No, it doesn't have to go down that
go
route
that
just as
far.
well.
You have sufficient trouble.
My lord, my lords, my lady, going back to the learned judge's reasons, we were looking at J2.
But wait a minute, just going back to this third judgment. At the end of the paragraph, he says he doesn't think the error in the opening words undermine the point being made in the paragraph as a whole, which was that to render a gift such as this of funds to the exchequer charitable, it had to be applied in reduction of national debt. So he is sticking with that view, it seems.
My lord, yes. In my submission,
I think one of the cases in the bundle is indeed a gift to the Chancellor of the Exchequer, which is held to be charitable.
yes, my lord, I can.
I can't remember which one, but maybe one of the older ones.
My lord,
Is it Nightingale?
if one goes to the appendix to our skeleton, the gifts are, the most relevant cases are summarised there.
Yes, Nightingale.
Yes, and that, as your lordship sees, that is referred to by Lord Halsbury in Pensel's case itself, number 6 in that summary. But my lord, if I may continue with our reasons, or our criticism of the learned judge's reasons, his third reason at paragraph 43 of the judgment it falls into two parts. What he says is that the his conclusion is reinforced by the fact that the subsidiary purpose was to reduce the national debt if national exigencies required it, and by the fact that the interest of the National Debt Commissioners was recognised from the beginning. My Lord, we say that those points, although the first of those points we say supports rather than contradicts our case, because what Mr Farrer was doing by allowing part of the fund to be released if national exigencies so required was to permit the trustees to dilute the integrity of his scheme, that the fund should be accumulated in circumstances where the interests of the nation required that to happen. And that shows that he was having regard to the interests of the nation in a broader sense than simply being advanced by paying off debt. And the second point he makes as part of that reason.
But the release of the fund, or part of the fund, under the proviso to clause 3A of the deed, requires the released part of the fund to be applied in reduction of the national debt.
Yes.
It's the only thing that it can be used for.
Yes.
So the government couldn't say, you know, we want to build some nuclear power station or whatever it is, we need the money.
No, my Lord, he is envisaging a situation where national exigencies require the government to have access to money to reduce the national debt.
Yes.
For example, a war, so that it can perhaps borrow more than it could unless the national debt were reduced. The consequence of money being released, if you like, prematurely to the National Debt Commissioners is that the nation loses the benefit of accumulation in respect of the part that is released. To the extent that money is released prematurely, it doesn't continue to accumulate under the terms of the trust deed. And to that extent, the donor's primary purpose is diluted.
And that's a matter of timing, because it was intended to accumulate.
Yes.
And it also is an exception to wipe out the debt rather than reduce.
Yes. And my lady, I don't want to take time by going to it now, but the trust deed contains a very wide investment power, unusual for its time. Basically, it was intended to enable the trustees to invest in the kind of assets that Barings were well suited to manage. And obviously, in our submission, it was part of Mr. Farrer's belief that accumulation, when managed by a firm as skilled as Barings, would be a powerful driver of an increase in the fund. And by releasing money prematurely out of their hands to repay the national debt, because national exigencies so required, he was compromising to that extent the integrity of his scheme. And we say that points in favour of a broader interpretation of the spirit of the gift. And my Lord, his fourth reason relates to the contemporaneous documents, and we've given the court our submissions on that. His fifth reason, in paragraph 45 of the judgment, is that given the relative values of the national debt and the national fund, it was not likely that the national fund would ever be sufficient to do more than effect a partial reduction of the national debt. And he says this provides some support for the conclusion that the spirit of gift was to assist him in the discharge of the national debt rather than to leave it by itself. Well, my Lord, our short comment on that, which we expand in paragraph 42 of our skeleton, is that that is not of itself a reason for saying that the spirit of the gift is broad, as we submit it is. So, my Lord, we submit that the learned judge's reasons given in paragraphs 41 to 45 of J2 do not support the conclusion which he appears to seek to draw from them in paragraph 40 and 46, that the spirit of the gift is confined to the reduction of the national debt. And those essentially are reasons for saying that the spirit of the first limb of our formulation of the gift is to be preferred to that of the learned judge. My Lord, there's one further point on...
Just before we leave this fifth reason, it seems to be inconsistent with what the judge held in his first judgment, and also inconsistent with the agreed expert statement, where they said that it was perceived at any rate, I don't know about likely, but it was perceived at the time that the National Fund on its own would, or at any rate might, pay off the national debt.
My Lord, I respectfully agree, and that is a point we have made in paragraph 42 of our skeleton.
Yeah, I can't now. It's in the agreed one of the two agreed expert statements somewhere. Immediately located.
My Lord, the joint expert statement is at tab 15 of the supplemental bundle.
There are two of them, aren't there?
Yes. The first is...
Yes, it's paragraph 18, isn't it? Page 148. Are the experts in agreement that in 1928 it was reasonable to believe that people expected the National Fund would be sufficient to fully discharge the national debt at some future date? Yes. I agree that.
Lord, I respectfully endorse your Lordship's point, and we also rely on the fact that the learned judge made a finding to that effect in paragraph 99 of J1, as we mentioned at paragraph 42 of our skeleton. So we rely on the points in paragraph 42 of our skeleton as a criticism of the learned judge's fifth reason. My Lord, there's one final point on this first limb of the spirit of the gift. If one goes to J2, paragraph 46, the learned judge said this: Mr. Pierce is content that the spirit of the gift was to benefit all citizens of the United Kingdom, has at least a superficial attraction to it, in that the discharge of the national debt would, if achieved, have benefited each and every citizen of the nation. For the reasons I've set out, however, I consider that is too broad an analysis, and that the spirit of the gift was given, the spirit in which this gift was given was to benefit the nation and all its citizens by attempting to free it from debt. Further, as I develop below, the scheme proposed by the trustee does not reflect the spirit of benefiting all citizens of the nation. And that appears in our submission to be a reference to paragraph 65 of the judgment, where the learned judge says this, second sentence: even if the trustee's gift is to be interpreted more broadly as benefiting the nation in the sense of every citizen of the United Kingdom, there is still a gap to bridge between that and the trustee's scheme. That is because if the funds were provided to to new trustees in order to provide grants to other charitable bodies, as the trustees in their discretion decided upon, that would not in fact benefit the nation. Only such part of the citizens of the United Kingdom that benefited from the charities to whom the grants were made. My Lord, in our submission, that is not a valid criticism of our scheme, because if the spirit of a gift can be broader than the original purpose of the gift, so it can be broader than a replacement purpose.
Can be broader than?
It can be broader than a replacement purpose.
I'm sorry, could you unpack that for me? What do you
Yes, my lady, of course. It's clear from Varsani and Lasani that the concept of the spirit of the gift is a broader concept
Yes.
than the terms of the original purpose. The same must be true when you compare the spirit of the gift and a proposed replacement or new or alternative purpose. The new purpose can be narrower than the spirit of the gift. It doesn't have to be coextensive with it any more than the original purpose is coextensive with the spirit of the gift. So insofar as the learned judge is saying that our approach is flawed, because if you set up a trust for the benefit of the nation or for general charitable purposes in the United Kingdom, not every citizen of the United Kingdom will benefit from it. And I'll come back to whether that's a correct criticism or not. But on the footing that it is, that doesn't undermine our proposed scheme. All it demonstrates is that the terms of the trust are, in the judge's view, narrower than the spirit of the gift that we contend for. But that doesn't matter, because a new purpose can be narrower than the spirit of the gift, just in the same way as the original purpose is narrower than the spirit of the gift.
I mean, I think a point you make somewhere is that the spirit of the gift doesn't, as a matter of logic or necessity, have to be exclusively charitable.
My lord, yes.
In which case, it's obvious that a replacement cy-près charitable gift may not be coextensive with the spirit.
My lord, I respectfully agree. My lady, did my answer
Yes, thank
sufficiently
you.
unpack what I was
Yes, thank
trying to say? I'm obliged.
Just to take an example far removed from this, if somebody leaves a gift to a charitable educational institute which doesn't exist anymore, you might say that the spirit of the gift is the advancement of education, but you can pick another single institution to receive the gift. So not everybody who is being educated would benefit from the spirit of the gift, but
Yes.
nonetheless the purpose is within the spirit.
Yes. Yes. But also, in my submission, the particular point that the judge makes at paragraph 46 and 65, there's a gap to bridge between our formulation of the spirit of the gift and our scheme, is not a valid criticism of our approach. So, my lord, if I can summarise our submissions on the first limb of our formulation of the spirit of the gift, we say that on the evidence, an element of the spirit of the gift was to benefit the nation without a restriction to reduction of the national debt, and that the learned judge's reasons do not support his narrower formulation of the spirit of the gift. My lord, may I move on and deal with our second proposed limb of the spirit of the gift, which we formulate in our skeleton at paragraph 32 as being a desire by setting an example to stimulate altruism in others. My lord, it was, we deal with this in our skeleton at paragraph 44 onwards. The learned judge accepted that it was part of Mr Farrer's intention to encourage others to do something similar. And in paragraph 45, we set out the passages in the documents that the court has been taken to, which demonstrate the correctness of that finding. The learned judge went on to give two reasons for declining to identify the spirit of the gift from those, for declining to identify an element of the spirit of the gift in those parts of those materials. First, he formulated the suggested element as to encourage others to do something similar. And he said this posed the question, similar to what? My lord, we submit that by formulating the question in that way, the learned judge went down a blind alley. The whole context of this investigation is one in which the purpose which Mr Farrer intended to set up his, for which Mr Farrer intended to set up his gift has failed. We accept that his desire to encourage others was a desire to encourage others to contribute specifically to his trust or to do something similar. But it cannot be right to say that just because that has failed, that is the end of that part of his of the spirit of his gift. The spirit of the gift has to be broader than the purpose. And we suggest that our formulation to stimulate altruism in others captures the spirit of what Mr Farrer was attempting to do, which is a completely separate question to whether his specific intention to encourage others to contribute to the reduction of the national debt has failed. And my lord, he also in our submission misled himself by inquiring whether the second limb of our formulation would itself be a charitable purpose. As my lord Launcelot Henderson has pointed out, that is not in our submission a requirement of the spirit of the gift. It does appear that the learned judge thought that it had to be. And so, for those short reasons, we submit that the learned judge ought to have held that an element of the spirit of the gift was a desire to stimulate altruism in others. So, my lord, if we're right on that, if we can move on to paragraph 51 of our skeleton, we submit that the learned judge should have held that the spirit of the gift consisted of the two elements there stated. And moving on from that, we invite the court to consider the implications of the spirit of the gift properly ascertained for the rival schemes. In paragraph 52(1) of our skeleton, we say that the trustee scheme better reflects the first element of the spirit of the gift than the Attorney General's scheme. My lord, on reflection, I don't think I can put the matter quite as highly as that. What I would submit is that the first element of our formulation encompasses both schemes. A desire to benefit the nation without limitation can be relied on to support both our scheme and the attorney's scheme.
Yeah, well, particularly if in practice gifts to the nation are used to pay down the national debt.
Well, my lord, yes, but I'm accepting that paragraph 52(1) of our skeleton put the matter too strongly in our favour. But my lord, it is clear that the second element of the spirit of the gift supports our scheme and points against the attorney's scheme. In our scheme, we propose that the terms on which the fund is settled or resettled should include a requirement to aim to give effect to what we submit is this element of the spirit of the gift. So if one goes to tab 14 of the core bundle,
Yes.
this is the order we invite the court to make.
Yes, paragraph 3.2.
Yes. My lord, yes. Just to explain this very briefly, the order proposes, the order requires the defendant to incorporate a new private company with articles that are in evidence and to transfer the fund to that new company, and the trusts on which the fund will be held are set out, as my lord has pointed out, in clause 3 of the schedule. And we invite the court to say that those trusts should include a requirement that the trustee should aim to achieve what we say are the elements of the spirit of the gift. My lord, we do not persist in saying that 3.2.3 should be included, because we are not pursuing our appeal against the judge's refusal to identify that as part of the spirit of the gift. But we say that the other three aims are properly to be included in the scheme. So in that respect, our scheme reflects this element of the spirit of the gift. And your lordships will, my lady, will have noticed that the evidence of Sir Stephen Barb describes how if the trustee of the charity thought it appropriate, it could carry forward that aim by, for example, making grants conditional on matching funding being obtained. That will be a practical way in which this element of the spirit of the gift could be carried forward by the charity under our scheme. And my lord,
by introducing a new clause to that effect, do you mean?
No, we simply...
Well, this is just a way in which the trustees under the new scheme could exercise their powers.
Yes, it's a way in which the trustee under the new scheme could give effect to the aim which they would have been given, of stimulating altruism in others. The question obviously arises, how would they do that? One way in which they could do that, if they saw it appropriate at the time, would be to make grants conditional on matching funding, whereby others would be stimulated to behave altruistically.
But you're not suggesting that they be required to.
My lord, no. My lord, absolutely not, because it's fundamental to our construction of our scheme. The way in which the new charity will be administered would be a matter for trustees of that charity, supported by an advisory board.
Yes.
It would be quite wrong in our submission for the court to try to dictate in advance how they should exercise their discretions. The crucial thing is to ensure that you have the right people on the trustee body and on the advisory board who are going to make correct judgments in the circumstances
Yeah,
in which
I
those
understand.
judgments have to be made. My Lord, going to paragraph 52(3, we say that it is plain that the attorney's scheme would not reflect the second element of the spirit of the gift. The learned judge made no finding that the attorney's scheme would stimulate others to make gifts to the National Debt Commissioners. No similar trusts have been established since 1932. There have been no donations to the National Fund since 1982. And as the evidence in support of the claim form recognises, these are the attorney's witnesses' words, there is no longer a social expectation of similar gifts. And the court has already been taken to evidence of the amounts that are given to the national, which find their way into the hands of the National Debt Commissioners for the reduction of the national debt. If we could look again, just very briefly, at the letter from the Debt Management Office, which is in what I think is page 8 of the appellant's bundle. The court there sees under figure 1, roughly in the middle of the page, the number of donations and bequests that have found their way into the donations and bequests account maintained by the National Debt Commissioners. And what is striking is that the numbers range from 2 in the current year, which is not yet finished, so that may be the wrong one to take. They range from 6 in a full year to 17. So in the period covered by these figures, only 6 people at minimum and 17 at maximum have chosen to make donations or bequests in terms which result in them being applied in reduction of the national debt. So the idea that the attorney's scheme would stimulate others to do the same is, we say, completely unrealistic. My Lord, if I may move on to factor B.
Can I just ask one question about factor A? We know that since 1823 there has been an account into which people could make payments to reduce the national debt. So had Mr Farrer wanted to do that, there was a way for him to have done it. And although this is not a document you have taken us to, the very first letter from Sir Otto to Sir Richard Hopkins on page 218, so that was precisely what Mr Farrer did not want to do. So there is an oddity about a cy-près scheme which does the very thing that Mr Farrer didn't want to do.
My Lord, yes. One could say that a formulation of the spirit of the gift that conflicted with his intention as between immediate or accumulation, if I can use those crude paraphrases, is flawed. We have some reservations about putting that forward as a positive argument, because it could be said against us that the spirit of a gift is a broader concept than the particular purpose. And so it could be said, I accept, that it is a legitimate abstraction from Mr Farrer's particular purpose to define the spirit of the gift as reduction rather than discharged.
And I
So-
suppose the other point that can be made against you is, well, there has actually been nearly a century's worth of accumulation already.
Yes. My lord, I don't want to abandon the point your lordship has put to me, but I don't put it in the forefront of our submissions because I see that it could be countered by the kind of consideration I've tried to articulate. But my lord, there is certainly a tension between Mr. Farrer's rejection of immediate payment to the National Debt Commissioners and accumulation, and identifying the spirit of his gift as being the reduction of the national debt.
Yep.
My lord, I accept that. Whether it is a fatal objection on its own is perhaps a more difficult point.
Right, so we're going on to factor B.
My lord, factor B. Well, the important point is that the words of paragraph B are that the court is to have regard to the desirability of securing that the properties apply for charitable purposes which are close to the original purposes. And in the context of the law relating to cy-près, as I shall hope have time to show your lordships from the authorities, the traditional formulation is that a new purpose has to be as near as possible to the object which has failed. And in that context, paragraph B expresses a dilution of the pre-existing legal requirement. Now, that being the case, it is too simplistic an approach to say that the attorney's scheme is closer to the original purpose than our scheme and is for that reason to be preferred. Both purposes are close to the original purpose, although they move from it in different directions. And where both proposed purposes are close to the original purpose, paragraph B does not say that the closer is for that reason to be preferred. So the short point arising under paragraph B is that both purposes are close to the original purpose, and paragraph B affords no ground for distinguishing between them, and so it should be seen as being neutral in the balancing exercise that the court has to carry out.
Yes.
My lord, that's all I think I need to say on paragraph B. Moving on to paragraph C, as your lordship and the court has heard, we submit that on a proper analysis, factor C or paragraph C points conclusively in favour of our scheme, a fortiori when combined with the others. And may I start by making some points about the language of paragraph C. Paragraph C requires the court to have regard to the need for the charity to have purposes which are suitable and effective in the light of current social and economic circumstances. This may be a relatively small point, but in paragraph 58 of J2, the learned judge appears to say that the explanation for that is that a new purpose should not immediately trigger a new cy-près scheme. We say that the word need means much more than that. It is that it is a requirement of a new scheme that it be suitable and effective in the light of current social and economic circumstances, and therefore that the new purpose to be established by a scheme must, in our submission, be selected from purposes which are suitable and effective in the light of current social and economic circumstances. So a scheme that adopted a purpose that was not suitable and effective in the light of current social and economic circumstances would be flawed.
Do you make anything of the distinction between the word need in C and desirability in B?
My lord,
Need on the face of it is a more compulsive term.
My lord, absolutely. That is a very important part of our approach. There is a clear contrast between the desirability of the new purpose being close to the original purposes and the need for it to be suitable and effective in the light of current social and economic circumstances. So if you look at the language of section 67 3 and just for the moment for the purposes of this point omit A and B, what you have is a requirement that I'm looking at the text on page 119 of the core bundle. The scheme has to provide for the property to be transferred to another. It has to be applied for such charitable purposes or transferred to another charity with purposes as the court considers appropriate, having regard to the matters set out in subsection 3. The matters are the need for the relevant charity to have purposes which are suitable and effective. So that is a mandatory requirement of the scheme in our submission. The court has to have regard to it, but the way in which paragraph C is expressed means that, as I tried to submit earlier, a new purpose has to be selected from amongst those that are suitable and effective in the light of current social and economic circumstances. The second point we make about the language of the paragraph is that it poses the question, suitable and effective for what? We say that you have to read something into the paragraph to answer that question. And we say that what you have to read into it is suitable and effective in providing charitable benefits. Because the whole purpose of the doctrine of cy-près is to give charities a new lease of life so they can continue to do good work, if I can put it that way, provide public benefit in changed circumstances. So it must, in our submission, be an obvious inference from the language of paragraph C that what the new purpose has to be suitable and effective in doing is in providing charitable benefits. And my lord, that is a point which the learned judge accepted in his third judgment, because if one goes to his third judgment at paragraph 9, which is on page 134 of the core bundle, he says, the defendant contends that I failed to conclude that suitable and effective means suitable and effective for delivering charitable benefits. It's true that it did not spell those words out expressly, but it's clear from the judgment as a whole that that is indeed how I understood the term. So the court has the benefit of the learned judge's second judgment to clarify that that is indeed how he understood the term. So moving on from that, what exactly do the words suitable and effective mean in this context? Suitable is not a difficult word to understand. It means it could be equally expressed as appropriate. Effective is, in this context, a more significant word we say that what the word effective means is that the new purpose has to have the quality of producing significant results. My lords, my lady, two dictionary definitions of effective, taken from the New Shorter Oxford English Dictionary, are powerful in effect, effectual, efficient, efficacious. Perhaps I could read that again. Powerful in effect, effectual, efficient, and efficacious. And making a strong impression, striking, vivid. Again, if I may repeat that, making a strong impression, striking, vivid. So, if one says, for example, he made an effective intervention in the debate, what the word effective means in that context, and we say it's the same meaning here, is that he did more than simply intervene in the debate. He made an intervention that had an additional quality than simply being an intervention. It showed the speaker's skills. It altered the course of the debate. It had an additional quality that was striking. And again, taking an example nearer to the current situation, if a trustee says, our charity has made an effective contribution, let us say, to raising standards of literacy amongst underprivileged children or something, or eradicating a particular disease, we've made an effective contribution. The trustee is saying more than the charity operated in those fields. He's saying that the charity made a difference, made an effective contribution. It achieved something. And I'll come back shortly to why we say that our scheme provides the charity with purposes that are effective in that sense, and the attorney's scheme provides it with purposes that are completely ineffective in that sense. And the next point to make about the language of paragraph C is that the words "in the light of current social and economic circumstances" provide the yardstick against which one is to assess whether a purpose is suitable and effective. They are the measure of the suitability and effectiveness of the purpose. And obviously, as the court well understands, our submission is that in the light of current social and in particular economic circumstances, the attorney's scheme equips the charity with a purpose which is not suitable or effective. And the final point we make on the language of paragraph C is this: whether a purpose is suitable and effective in the light of current social and economic circumstances has to be assessed by considering the purpose on its own terms, not, for example, by reference to the purpose which has failed. So it would be a mistake to say that a purpose is suitable and effective because it is in accordance with the spirit of the gift, or that a purpose is suitable and effective because it is what the donors would have wanted, or that it's suitable and effective because it is close to the original purpose. Each of those approaches is flawed because the Speaker is not evaluating the purpose in its own terms by considering whether it's suitable and effective in providing charitable benefits. He's evaluating it by comparing it with, in my examples, the spirit of the gift, the donor's presumed wishes, the terms of the original purpose.
So what you're saying is C stands alone and shouldn't be coloured by A and B, because C in its terms is looking at the here and now, the new charity.
My lady, precisely. That's exactly our submission. And the evaluation of the purpose as against the spirit of the gift and the original purpose, they come later. They come as part of the balancing exercise. But in order to determine whether a proposed purpose satisfies the need that paragraph C articulates, you assess it on its own terms by looking to see what it actually would do. Now, as the court well knows, our appeal is that there is an obvious sense in which the Attorney General's scheme fails to satisfy paragraph C. We say it makes no difference, it would make no difference to anybody or anything if the National Fund were applied in reduction of the national debt. We say it disappears, except as a book entry.
Well, the experts agreed that it would have what they described as a negligible effect.
Yes,
And normally, if something's negligible, you ignore it.
yes, my lord, precisely. But I hope your lordship will forgive me for labouring this point slightly because it is so important. And we say, by contrast, there's an obvious sense in which our scheme satisfies paragraph C. A large charitable fund would be settled on trusts which have the potential to do much good for the whole of the United Kingdom. My lord, just to expand on those points slightly, the learned judge accepted in paragraph 68 of the second judgment that the National Fund would only have a minuscule effect in reducing the national debt. Minuscule is a strong word, but I do ask the court to look briefly at the examples we gave in footnote 3 of page 5 of our skeleton, for which I have my junior Mr. Burton to thank, which expressed the difference between the magnitude of the national debt and the National Fund by converting them into concepts of time and distance. Those practical examples we submit are striking in a way that just looking at a row of noughts is not. My lord, if I can briefly take your lordship and the court to Professor Ellison's evidence to build on the point which your lordship has already articulated.
Well, we've got the agreed statement at page 163, paragraph 20.
Yes, my lord, what I wanted to do, if I may, if I can just trespass on the indulgence of the court for a little longer on this point, is to take your lordship, as well as to that statement, to Professor Ellison's first report, where he, in paragraph 8, 6 and 8, 7 on page 133, gives technical definitions of the terms,
Sorry, where are you? Page one,
page 133, I hope I said that,
three.
of the supplemental bundle.
Yeah.
He defines here the terms the government's primary budget balance and the government's general budget balance. And those definitions are agreed by the joint statement at page 146 of this bundle, except for one clarification, which doesn't impact on the submission I'm about to make. So if one has those terms in mind, the difference between them being that the general budget balance includes interest payments on debts and the primary budget balance excludes interest payments on debts. If one has those in mind and then turns, because if we may do it, it's easier, to Professor Ellison's third report, which is at tab 20 of the supplemental bundle. As your Lordship knows, the figures are updated in his latest report. But in this third report, at paragraphs 15 and 16, he describes the deficit in the UK's general government balance in the years that he's considering. And your Lordship see that there is a forecast deficit of 83 billion in 2023, expected to stabilise at around 44 billion. And in paragraph 16, he explains that the UK general government budget deficit continues to be financed by government borrowing that increases the national debt. So in broad terms, the government in the years that he is discussing is spending more than it receives, to the tune of £183 billion in 2021 to 2022. And your Lordship and my Lady can look at my Lord and my Lady can look at the fourth report for the updated figures. And if we stay with this report and turn over to page 216, we can see that Professor Ellison concludes that reducing the national debt by the amount of the national fund would have the effect, and I'm looking now at paragraph 25, of reducing the interest payable on the national debt in real terms by £5.6 million a year. And the figures are slightly different, they're slightly more favourable to my learned friend if you go to the fourth report. And the figures are striking because it is inconceivable that reducing what the government has to spend on servicing the national debt by a sum of the order of 5 million, or even slightly higher figures in Professor Ellison's fourth report, will make any difference to anybody or anything. One sees from the earlier paragraphs of Professor Ellison's report what the annual deficit is and is predicted to be on the government's general budget. It is huge. And the Attorney General scheme, one can't really put it any other way. It just makes no difference to anybody or anything. The money is lost, except as a book entry. And for obvious reasons, we submit that that entirely fails to satisfy the requirements of paragraph C. The attorney's scheme does not equip the charity with purposes that are suitable and effective in the light of current social and economic circumstances, because in the light of current economic circumstances, the new purpose is not effective in the required sense. It makes no difference. If one goes back to my examples of what we say is the correct meaning of the word effective, he made an effective intervention in the debate. This is not an effective provision of charitable benefits. There is a causal connection of a kind between the transfer of the money and there is a causal connection between the transfer of the money from the National Fund to the National Debt Commissioners and the statement of the balance owing on the national debt. But the payment has made no difference to the provision of charitable benefits. My Lord, that is basically what we say about paragraph C. May I take the court to the way in which the learned judge dealt with this issue in his judgment? If we go to J2,
68 and following.
my Lord, I'm most grateful. It's important to start by appreciating the structure of his judgment. He deals with factors A and B down to paragraph 56, and in paragraphs 57 to 64 he deals with factor C, and the way he deals with it is essentially to describe and accept the evidence of Professor Ellison.
Yeah.
And I obviously rely on Professor Ellison's evidence and the judge's acceptance of it. Then, after paragraph 64, he embarks on a new section of his judgment, which he describes as being the application of the 67 fee matters to the rival schemes. And he deals in paragraphs 65 and 66 with factors A and B. He then, in paragraphs 67 to 70, deals with our submissions in certain respects. And then in paragraph 71, he states his conclusion: I've concluded that taking account of current social and economic circumstances does not point significantly in favour of the trustee scheme to tip the balance in its favour when weighed with the other two factors. And one would expect, and it is to a large extent the case, that paragraphs 72 to 76 of the judgment are an articulation of the judge's reasons for striking the balance in that way. But in our submission, you get from paragraphs 72 and 76 some more reasoning from the judge about paragraph C specifically. So these paragraphs are not simply an evaluation, they are also further reasoning about the judge's approach to paragraph C. And
what is the distinction the judge is drawing in 72? What is the contrast that he's pointing to there?
in paragraph 72,
Yes. He says it's no part of his function to decide what he thinks would be the best use of the National Fund. It's to determine what is the most appropriate use. And I don't quite...
well, my Lord,
but it must be what he considers the most appropriate, mustn't it? Bearing in mind the words of section 67.
yes, my Lord, I read that paragraph as saying this.
Is it just that he hasn't got a free hand? Is that all he's
Yes,
saying?
I think that's what he's saying. I mean, I think the point he's making, which obviously rings true, is that everybody has their own ideas about what should happen to this fund.
Yeah.
It's not for him simply to give effect to his own idea. He has to apply Section 67(3). That's what I understand you to be saying there. Now, my first point about the way in which he approaches this part of his judgment is this, that in paragraph 73, he appears in our submission to be adopting a wrong meaning or a wrong sense of the word effective. He says in the second sentence, however small the amount by which the national debt is reduced, the nation, which is the debtor, benefits directly by that amount. While superficially attractive, I do not think the utility of gifts to repay the national debt is measured by the extent to which citizens receive any benefits themselves. And then, if I can move over the next sentence, the last sentence is important. The fact is that in the eyes of Mr. Farrer and others motivated to make charitable gifts in reduction of the national debt is itself a burden on the nation, and to reduce the burden on the nation is a worthy object. So, in our submission, he's applying a meaning of effective which simply looks to there being a cause and an effect. He regards the requirements of paragraph C as met if the national debt is reduced by the amount of the national fund. But in that respect, he is not giving the word effective its proper meaning, as I have submitted it to be. And one gets the same point in our submission from J3. If one goes to J3 at paragraph 11, he's criticising our proposed grounds of appeal at this point. If I can start to read halfway through paragraph 11, ground 5 asserts that I was wrong to regard reduction of the national debt as a sensible and effective purpose simply because it will cause the national debt to be reduced by the amount of the payment. This argument assumes that there is no practical benefit in so doing, because practical benefit must be measured by reference to the extent to which it provides a benefit to any particular person or thing. For reasons given, I do not accept that assumption. I do not think there is an arguable error of law in my conclusion in the context of a gift whose spirit is to benefit the nation by reducing the burden of national debt. There is practical benefit in the very fact of that burden being reduced. So, my lord, he is in our submission applying the wrong sense of effective. And he's also in that paragraph, which is I should remind the court, part of his additional reasoning. He's also committing another error in our submission, because we submitted that you have to evaluate whether a purpose satisfies paragraph 3 by considering the purpose in its own terms or on its own terms. And one can see from the last sentence of that paragraph that he's not doing that. He is assessing whether the purpose satisfies paragraph C in the context of a gift whose spirit is to benefit the nation by reducing the burden of national debt. So he is committing in our submission the error that my lady, Lady Justice Asplin, asked me to articulate or to explain as part of my unpacking of paragraph C. He's assessing whether a purpose is suitable and effective by considering the context of the trust from which the fund derives, which is, in our submission, wrong. You come to compare the original purpose of the fund and the suitability and effectiveness of the new purpose at a later stage as part of the balancing exercise, not as part of considering whether paragraph C is satisfied. My lord, going on, we can see it, if we go back to J2, the judge, in his concluding paragraphs, attaches weight to the views of donors to the fund and the views of people who donate money directly to reduce the national debt. The learned judge clarified in J3 paragraph 12 that in this respect he was not solely addressing paragraph C, but he was addressing it to some extent. If I can just read the court what he said at paragraph 12 of J3. He said paragraphs 73 and 74, I'm reading 5 lines down paragraph 12 on page 135 of the core bundle. Paragraphs 73 and 74 are not focused only on section 67.3c. So they are to some extent concerned with 67.3c. And what the learned judge says about the views of donors is basically this in paragraph 73. The fact that in the eyes of Mr Farrer and others motivated to make charitable gifts in reduction of the national debt is itself a burden on the nation, and to reduce that burden on the nation is a worthy object. He goes on to give examples of others who gave small amounts. And he concludes at the end of paragraph 74, even the gift of just over £2 would, once paid to the National Debt Commissioners, have the consequence of reducing the national debt by that amount. My lords, my lady, what we say about the judge's reference to the eyes of Mr Farrer and others who donate to the National Debt Commissioners is that these are irrelevant under paragraph C. The views of donors are taken into account to the extent that the legislature thinks it's appropriate that they should be taken into account by paragraphs A and B. And that it is
Why are the views of other donors relevant?
well, my lord, they're not in our submission. In fact, as already submitted, they help us rather than hinder us, because although there are, I think what my lord, what he's talking about is people who give money to the National Debt Commission,
Yes.
otherwise than through a trust such as his.
Yes.
With respect, no, it's not what paragraph 74 says. The evidence in this case reveals others who donated to the National Fund.
Oh, and donated to the National Fund, yes. Yes.
Yes,
I think he does talk about the British Legion, doesn't he? Yeah.
yes, my lord. I was thinking of what the learned judge said in J3. Yes, in paragraph 12 of J3, on page 135 of the core bundle, 6 lines down. Secondly, the last sentence of paragraph 73 is not referring to the motivations of the donors, but to the motivations of those, including the donors in this case, who made charitable gifts in reduction of the national debt. So, my lord, I think it's right, based on that, that the last sentence of paragraph 73 of J2 is talking not only about those who donated to the National Fund, but those who donate directly to reduce the national debt. And his point is that in the eyes of those donors, to reduce the burden on the nation is a worthy object. Well, my lord, we accept that those who give to reduce the national debt are giving money to a worthy object. It is a good thing to reduce the national debt. It's a charitable purpose, and we don't say anything to denigrate from the generosity and public-spirited sentiments of those who do that. But if and insofar as it is relevant to look at the views of people who donate to reduce the national debt, Your Lordship's may see from the letter from the DMO that they are just a handful of people. Your Lordship saw the court saw the numbers of donors from the DMO's letter. So the numbers who think it's something which is worth doing are extraordinarily small. And whilst we accept that giving money to reduce the national debt is a worthy object for which donors should be thanked, that doesn't mean that it's an appropriate purpose to select as a new purpose for this charity on a correct application of section 67(3). You can have a charitable purpose which is, in the eyes of those who want to support it, worthy, but which is a wrong choice as a result of the application of these statutory criteria.
Well, it's still left with the the difficulty, or perhaps it's not a real difficulty, though I think the judge perhaps thought it was, that making only any gift, even of a quite substantial amount of the National Fund, it is for all practical purposes going to be an exercise in futility, but nevertheless it's accepted to be a valid charitable gift with all that goes with it, and it must therefore satisfy the test of public benefit. It entitles you to tax relief if you make the donation, and so on and so forth. So isn't perhaps the risk of the court being asked to second guess, so to speak, these issues when they're already conclusively determined by the fact that it's common ground that the National Fund is a charity with all the baggage that carries?
Yes, the National Fund is a charity. Reducing the national debt is a charitable purpose. But the question which section 67(3) requires the court to address is, what is an appropriate charitable purpose to select as a new purpose for this charity, its purpose having failed? And plainly, because reducing the national debt is a charitable purpose, it is not disqualified from being considered. The question is it an appropriate purpose to select on a proper assessment and balancing as against one another of the factors in 67(3)? And as I've already indicated, we say that on a correct assessment of each of those factors and the balancing of them, the answer is no. And it's important, we stress that because of the enormous, almost incomprehensible discrepancy between the National Fund and the national debt, using the former to reduce the latter is simply not a suitable and effective way of providing charitable benefits in current social and economic circumstances. So, my lord, there's no inconsistency between our ready acceptance that reducing the national debt is a charitable purpose and our submission that it's the wrong purpose to select by an application of the section 67(3) criteria.
Just to be clear, views of donors, you say, is irrelevant under C or any of the limbs of 67.
Well, my lady,
Do you?
they are irrelevant in this sense that the legislature has not chosen to express them as factors to which the court is expressly required to have regard. It's covered the ground in a different way by asking the court to consider the spirit of the gift and to consider the desirability of a new purpose being close to the original purposes. Those cover the same ground in a general way as asking what the donor's intentions were. But, my lady, there is a good reason for not asking the court, as Parliament has refrained from doing, to consider the intentions of donors specifically. And that there are really two principal reasons. The first is that how can one know what a donor would have wanted to happen in circumstances where his gift has failed?
Well, certainly in the case of disaster funds, where lots of people contribute very small amounts to a disaster, which is then resolved somehow or another, it would be an impossible task.
Yes, and in this case, it is an impossible task to know, in this case, what the people who donated the £2, 19 shillings and so on, would have wanted to happen a century later, in circumstances where the noble idea of reducing the national debt by everybody putting money in together has failed. How can one say that they would have wanted it to go to the National Debt Commissioners regardless, or whether they would have said, well, I'd rather it went to somewhere that will do some practical good? One cannot know. And the other reason why it's wrong to look at the intention of donors is this, that it's a circular argument in a way. If you give money to charity, you give it to an institution which has the benefits of being subject to the court's supervision, in particular by the court having power to make a cy-près scheme if the purposes fail. So you trust the court to make new purposes for the charity if the purposes for which you've given the property have failed.
Yeah.
That is part of, if you like, the part of what you buy into when you make a charitable gift.
Of course, that rules out any question of a resulting trust in
Yes.
normal circumstances.
Yes.
But
If you don't want the court to decide what the new purposes should be if your gift fails, you can specify alternative purposes for that eventuality. But of course, in this case, that wasn't done. So it is a matter for the court to apply the law to determine what should happen to the fund. And Section 67(3) does not specify the intentions of the donors as a relevant consideration. And I've tried to indicate why there are good reasons why it shouldn't. My lord, would that be a convenient?
Yes, by all means. How are we doing for time?
My lord, I have a certain amount still to go through. I then have to deal with the authorities, but I think I can deal with the authorities fairly lightly, because although it's right the court should be aware of some of the more significant cases on the subject, very few of them are likely to be of great assistance in this particular context.
Yeah.
So with the court's permission, I will go through the authorities fairly lightly.
All right, fine. 2 o'clock.
All right.